suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Our real good lawyer is here in attendance, as they say. Melbourne solicitor David Whiting here to answer your questions and help you out. Hello, David.
Hello, Virginia.
What's happening in your world?
Oh, it's pretty quiet at the moment. It's lovely. So,
No homework, everyone happy?
No, well, everybody's reasonably happy.
Reasonably
yes, no
happy.
homework. Yep.
Well, I've got a couple of lines free, which almost never happens. 1300 222 774. This is the hottest ticket in town. So if you'd like free advice from David Whiting, go right ahead and grab those lines. And we can just get started into it. Got any news for us?
No.
What's going wrong here?
Well, I tried to go to court last week, but they were all on Zoom. So
they've gone back to that, have they?
Well, it's most of them haven't stopped, but it's interesting. If you have a court matter, they normally tell you to come at 10 o'clock in the morning, and you'll generally be heard sometime between then and 4. But when they do it by appointment, it's so much more effective.
Yeah, gets done in time.
Turn up at 11. I think it probably slows the judges down a little bit, but in terms of if you like, the barristers and the solicitors involved and the parties, it's just so much more convenient.
Well, Margarita in Beaconsfield, you get to ask your question to David straight away. Go right ahead. Good morning.
Thank you. Good morning, David and Virginia. About 2 weeks ago, we sold a car to a person, and she inspected the car, had a drive with it, and blah, blah, blah. She paid a deposit, and she wanted the car. Now she's made up her mind that she doesn't want the car and wants to buy a car elsewhere. What do I do with the deposit?
Well, you don't sell cars for a living, do you, Margarita?
It was a private sale.
Okay, then the answer would be that the Fair Trading Act issues and consumer law don't apply to you. As far as you're concerned, it's a sale.
Yeah.
Now, you can do a couple of things, but the logical thing would be to agree that you will sell the car again, and to the extent that you're out of pocket as a result of the resale, give her back whatever's left of the deposit. But she's got no right to, at law, to change her mind. Right? So you've got an enforceable contract of sale, but the logical thing is resell the car, and there'll be more advertising costs, and you might end up selling the car for a little bit less. You might even need to get another roadworthy. And then
it was booked in for a roadworthy today, and the car would be delivered upon receiving the roadworthy, and then she would pay the balance.
Yes, well, I would suggest the roadworthy's good for 30 days. If you think you can sell it in 30 days, put it back and advertise it. Accept her rejection of the contract, or tell her what you're proposing to do is accept her repudiation of the contract, and you will account for the deposit when you resell a vehicle.
Well, all she wants to do is to pay the money back, because now all of a sudden we get the stop source. She's got a young family and all this sort of thing. Well, she had a young family when she bought the car.
Yes, she did. Right? I imagine she did. Yep.
Oh, we're tough out there in resale land. So none of those normal expectations apply if you're just a private seller. None
of the consumer law provisions. It's got to be in trade or commerce. Right. So if you sell cars for a living, there's a set of rules. If you don't sell car for a living, those rules don't apply.
If you mislead someone in the selling of a car, the normal rules and regulations don't apply if you're just a private person?
There's a tort of deceit.
Okay.
So some of them are actionable, but the what I'll call the statutory remedies just aren't there.
Okay, all right. Jay in Clayton. Jay, go right ahead with your question.
Thanks, Virginia and David, for the chance to call in. I put up my house for sale a couple of months ago and engaged a real estate agent who was insisting on selling it through an auction. And for the price that I was expecting, he advertised the house at a much lower price. And then I did tell him that that's not the price I'm looking at. But he said, "Look, leave it with me. I'm the professional. I'll deal with it." Then obviously at auction the house passed in because it wasn't getting the price that I was expecting, and then he put it up for private sale. And after then the drama started.
But Jay, the problem is that the agent, did the agent give you any indication of what he thought he would sell for?
Yes, he did, and
then the agent then does two things. He gives you an estimate of the value, and he puts an estimate of the value on the website. So the problem is that the auction has set the market's expectation for the value of the house. That's your problem. Yep.
Yeah, but no, the bigger problem is once it was up for private sale, we got a buyer who put in a bid, and that I wasn't completely happy. But then over 2 days, he would turn up at my house at odd hours. He would just pressure me to sign the contract, telling me the buyer will go away. So to put him off my back, I said, yes, I'll sign the contract, but give me a couple of days. And then he would still turn up at odd hours. And then one fine day, he and his boss came to my house. They started hurling abuses, saying, why are you not signing the contract? You're wasting our time. And then, so to get them off my back, I signed the contract because I was under so much pressure. They wouldn't leave my property.
Yes.
And now, what's the recourse I have? Is it kind of a coercion?
None. None. They endeavoured to. Their argument will be that they endeavoured to persuade you to accept an offer that was the market value of the house. You could have said no. You could have gone out. You could have gone for a walk. You could have done all sorts of things. I understand that you're under some pressure, but I don't know, unless you're saying that they came with a very large stick and or some gloves and were going to thump the hell out of you, then I don't see that you'll meet the coercion. And the difficulty would be you've got market value for the house. Now, your choices were market value or don't sell.
Yes, so...
And you chose to sell.
But being aggressive on my property, camping at my property, not leaving till I sign the contract, isn't that coercion?
I don't think you'll meet the requirements for coercion, but you could make a professional standards claim. There's there are conduct rules. Absolutely. But my problem with most estate agents, Virginia, is that when they get a listing, they're acting for you. When they get a buyer, they start acting for the buyer.
Yeah, that's very true.
So that's the difficulty.
Well, what would meet the standard of coercion?
I would have assumed that, I would have suggested in most cases it would be threats of physical violence.
Were there such threats?
There were. So he was, he really came up onto my face and shouting and hurling abuses to my wife as well while we were still discussing.
Then that might constitute assault, which is a criminal action. But your difficulty will be... So my problem, Jay, is what's the value of your loss? Right now, your loss is the difference between the market value of the house and what you got for it. So where you're talking about is the difference between your expectation and what the agent got. Now, that's the difficulty in practical terms. Where do you go from there? I was coerced into selling a property at a price I didn't agree with, and my loss is... what?
Something more that you wanted.
From a procedure perspective, the way they dealt with it, is there a recourse I have?
Okay, well, let's leave it with that.
Only with a professional standards question. You might complain if they're a member of the REIV, you can complain to them. You can also talk to Business Licensing or Services Victoria, because there are regulations relating to the conduct of estate agents, and you can have a look at those and you can make a view where you want to go from there. Okay,
and maybe have a think about whether you want to go to the police about that constituting assault.
You could, yes.
That aggressive behaviour there. Good luck, Jay. Sorry about that situation panning out in that way. Gavin in Geelong. Go ahead, Gavin. I've got a few car questions today.
Yeah, my question to you is I purchased a brand new car only a couple of weeks ago, but I had my car for trading, which they had the registration probably about 3 or 4 months prior and gave me a set figure, which was really nice. The deal was done. They got the car, this was only about 2 weeks ago, picked up my car, paid in full, signed all the paperwork, the whole lot, got home, enjoying my new car. Then I get a phone call and a message saying, we have a problem. Your trading car was a repairable write-off. Now, they said we want compensation for it, and I thought, okay, but wouldn't you have done due diligence and done it before you actually did sign the contract? Somebody, where do I stand legally there?
Well, again, it's almost like the reverse of Margarita's question. None of the fair trade, the statutory remedies apply in your case, because I'm assuming you're not a car trader.
No.
And I would have suggested that it's the dealer's problem. It's not yours. They had the ability to assess the vehicle. They assessed the vehicle. They formed a view as to its value. End of discussion.
Gavin, what's the problem with you keeping the car if it's working fine?
No, he's already delivered the trade-in.
Yes.
He's picked up the new car, delivered the trade-in, and he's paid the balance to the dealer. The dealer is now coming along and saying, I want to renegotiate the value of the contract because I now think that the car I agreed to buy from you isn't what I agreed to pay.
I see.
So I'm on your side, Gavin. I don't think you have to do anything.
I did ring up an independent car dealer friend of mine and asked, where I stand with that, and he just Googled the registration within 2 minutes and said, yep, it's a repairable write-off. And I thought, well, they had the registration for 3 to 4 months prior. Why didn't they do that? It's, now
even repairable write-offs have a value, Gavin.
Yeah.
Right? Now, they put a figure on it. They've agreed to pay that to you. That's the end of the discussion. Because unless the documentation that you've signed contains a series of warranties as to the quality of the trade-in, that's the end of it.
All right.
Thank you kindly for that.
So you're in the right and you're in a comfortable position there. 1300 222 774 if you'd like to get some advice from David Whiting. Mary in Dalesford, how can David help?
Oh, thank you, Virginia and David. I have a vacant block in a nearby small country town, and I was very surprised to find it had been slashed and 2 10-metre gaps opened up in opposite fences. I eventually found, was provided with the phone number of the partner of the woman who'd authorised the slashing, and it was mistakenly done.
Okay. So what's the question, Mary?
Well, the question is, I've spoken with the contractor. He says I'm lucky it was slashed. He was paid for doing the job. There were no fences there. And in a way, he's right, because it was hedged. The fences were very old and were overgrown by vegetation, but were intact boundaries. So he had no trouble going through them and pushing down the existing wire underneath.
Yep.
So I've had to have the gaps re-fenced as basically as I could with star pickets and ring lock wire.
Yep.
Which cost about $360. So my question is, am I entitled to any reimbursement? And is that the contractor who did the job, which obviously was by mistake, or I've done a title search and found the owners of the other block?
Right. Let's try and break that up. There's a provision in the Fences Act that says no one will do any fencing without a court order or the consent of the neighbour. Unfortunately, there's no penalty in the legislation for that, and so I don't know where that particular problem goes in that situation. You have the right to insist upon the replacement of fencing. So if a fencing contractor engaged by your neighbour, and the fencing contractor will tell you who engaged him, will be able to tell you who's responsible for the work that he did. So you're responsible for the tradespeople that you get to do work. So I would suggest you've got a claim, but we're talking about $300 of fencing. I can tell you'll be significantly out of pocket if you take the matter further. You could issue a fencing notice to fence the whole of your block. I just don't know whether it's worth your while to do that.
So do you think that Mary should just walk away from this?
Both of the fences are adjoined public roads. One's a main road and one's opposite a hall which has big events, which is why I had to reinstate.
If they're facing roads, your claim is against the person who engaged the contractor for the damage caused to your property as a result of the fencing work. I don't know. You may make a claim in relation to the slashing, but this is a domestic block, a residential block in a little town, Mary?
Oh, I'm not worried about the slashing.
Okay, then your claim is against the cost of fixing the fencing, but you're not going to get costs for a claim less than $300 in the magistrate's court.
All right.
So I would probably swallow it. I just don't see that there's a financial return for you in getting anything done.
Mary, sorry David had to say that today, but that seems to be the best place to land. If you'd like to call in, I'll have a line free in just a moment after we speak to Jess in Beaumaris. Jess, go right ahead.
Oh, hello, David. I've got a car accident issue. I backed into someone about a month ago, and I've just received the quote. I didn't think there was much damage, but it's coming through about $2,000. I was going to pay. I have insurance, but I was going to pay if it wasn't too much. But now it's too much, and I'll probably go through insurance.
Mm-hmm.
But my question is one quote just enough? Like, can I make them?
You can't make them go and get additional quotes. You can get an assessor to go through the quote and make sure that it's a proper assessment. I mean, the reason why people ask for 2 or 3 quotes is so that they can be satisfied that they're paying market rates for the work. But there are automotive assessors that you can find by Googling, looking on the net, Yellow Pages, and you can send them a copy of the quote and tell you whether it's a standard figure or not.
Okay.
And that's where I would take it.
But the one quote, as it stands, is sufficient.
All that insurance companies only ever give you one quote.
All right, good to know. Good luck with that. Claire, calling from the Western District. Good morning.
Yeah, hi. Hi, I've got a situation where my mother left the house but allowed my brother to reside in there for however he would like.
Yes.
Unfortunately, he is quite hostile towards me and my sibling.
Who's the executor of your mum's estate, Claire? Is it your brother?
Yes, my brother.
So the brother who's living in the house is also the executor?
Yes, that's right.
And there'll be a clause in the will that says, I'm allowing my son X to remain in the property so long as it's his principal residence.
Yes, which he just sold his unit as well. So then he's just got
he's just living in the house. So what's the question, Claire?
The question is that just doing a condition report on the house. I don't think.
Why are you doing a condition report on the house?
Because he's a tenant, and
He's got the condition report is a requirement for the Residential Tenancies Act. When there's an arm's length landlord and an arm's length tenant. In this particular situation, he is both the landlord and near enough to a life tenant. So he's not required to complete a condition report. And the difficulty in...
But in the will, it stated my mother put in that he has to maintain the house. But we believe that we know that he won't, because he did reside with Mum for 15 years.
Claire, the only way you're going to achieve this is by a court order. There's nothing that gives you the right as a beneficiary to insist that he goes and gets that a condition report in respect of the property is prepared.
Okay then. All right then, thank you.
Sorry, Claire.
Yeah, sorry, Claire, not the answer that Claire wanted there. Rebecca in Hyatt. Rebecca, what's your question for David?
I do, thanks, Virginia. David, I've got a question about a gate that is currently located on a shared driveway, which is common property. And so there's a body corporate that's not active overseeing that. And whoever built the gate put it in the wrong spot, essentially. And I live in the back unit, and I'm happy to pay for a new gate. But my question is, if to get the gate I want, do I have to relocate it to the boundary, which is basically 5 metres back? I don't really care, but is it safer to do that? The existing gate's been there for 20 years.
And the gate separates the bit you occupy from what the person in front occupies, is it? So essentially it's your entry gate.
Yes, we're the only ones that use it. They come off the driveway at the very, very front by the footpath.
Yep.
And we drive up the driveway about 10, 15 metres. Then there's the gate. Then there's another 5.5 metres of common land, and then there's our property begins.
So why would you not simply approach the people at the front and say, can I replace the gate with this gate? I mean, that's where I would start the discussion.
It's a little bit difficult. We don't really get on, unfortunately.
Well, you could create... in theory, the gate is part of the common property. You've got no right to remove the gate without your neighbour's approval.
Yeah.
So
okay.
I would start the discussion with, can I replace the gate? It will look like this, and I'm happy to pay.
Yeah, and if not, we can't remove it. Yeah.
Well, no. You could move the gate, but you couldn't. You could put in another gate on your boundary if you wanted to. I'm just conscious that the gate will be an asset of the owners' corporation, of which you are only half a member.
Yeah, I thought that might be the case. It's just that it's rusting, and I went out and rust-proofed it and started to undercoat it, and then she came out and said, I wanted this colour to match my guttering on my house, kind of thing.
Yes.
That's the level we're at. So
Could you match the colour? Could you live with that, Rebecca?
I was just going to put in a steel gate, which is black, but...
well, could you get a better outcome by meeting in the middle here, give her the colour she wants, and there you go, you fix the gate?
Yep.
And a brand new gate.
But it's a brand new gate which is closer to her house than it is to yours.
Yes, it is. Yeah.
So why don't you get your steel gate and get it dipped the colour she wants? Or is that losing?
No, it's not about winning or losing. It's about just the easiest path for me, to be honest. And it's an awful khaki, sort of fawny, horrible colour.
Oh,
like how everyone just puts in black.
Whatever you do, don't tell her that.
I wouldn't die in a ditch about the colour.
No.
Not if you're going to end up with the outcome you fundamentally want, but we'll leave you to consider that. There's David's best advice. I think we can fit in just one more before we go and talk about finance, and we'll end with another fence dispute. It's our favourite. Ash, good morning. Go ahead.
Hey, David. Hey, Richard. Just a quick one. We had a neighbour. It was a new block, and we had constructed before him, and we had paid for the fence. And by the time he had come on board, and then we sent him, okay, here's the cost. Here's what you need to pay. But he basically failed to.
Ash doesn't have to pay.
So he doesn't have to pay.
No, the obligation to pay is in respect of a prospective fence, not a retrospective fence.
Yeah.
You're the first in You're the first in the development, and you build the fence for your privacy. Your neighbour gets the benefit. I act for a couple of developers, and we actually put a clause in our contract that says, well, you can have a fence, but if you ask the developer to contribute, our contribution will be $1.
Yes, but he had acquired the block by then, and we had sent him a notice. The only reason he disputed was because he said our contractors who done our driveway put soil and sand dumped on his side, and that's why...
Well, that may be the reason for the argument, but you can only get him to pay by agreement or a court order, and you've sent the fencing notice. If you don't get what you want from the fencing notice, it's the magistrate's court, and you're too late.
Yeah, okay.
At least you got the fence you wanted, not the fence your neighbour wanted.
I think we have to get our listeners to swap fences and gates and somehow sort it out amongst themselves. Maybe.
Oh, that's an encouraging thought. Thank you, Virginia.
David Whiting, back with you next Tuesday. Thank you, David. Always a pleasure.